Duduling na ako.
1, 2, 3, go.
Good day, ma'am. My name is Angelico J. Padua, section of OLSA 22E21, subject of CPLJ3. Today, I will reciting the following question and my answer. So, number 1, what is evidence? Is this means sanctioned by these rules of ascertaining in a judicial proceeding that the truth respecting a matter of fact? Question number 2. Define proof. Proof is the effect of result of evidence. It is the perfection of evidence, and also proof is the end result, whereas evidence is the means to the end. Question number 3. What is evidence? Di bini esse. The court may, if it appears likely that any attended witness in any proceeding will not be able to give evidence at the trial, or likely that any intended witness in any proceedings will not be able to give evidence at a trial or hearing. Record the evidence of such witness in writing, and such evidence may be used as the evidence at the trial or hearing. Question number 4. What is difference between factum probandum and factum probans? Factum probandum is the proposition sought to be established, and factum probans is the material by which the proposition is established. Question number 5. What is meant by probative case? Probative case of evidence refers to the question of whether or not it proves an issue. Question number 6. What are the sources of Philippine rules on evidence? There are 12 rules in sources of Philippines evidence. The number 1 is provision of the 1987 Constitution on the rights of the accused. Number 2, Rules 128 to 133 of the Rules of the Court. Number 3, Resolution of the Supreme Court dated March 14, 1989 on the proposed rules on evidence. Number 4, Judicial Affidavit Rule. Number 5, Rule on Examination of Child Witness. Number 6, Rule on DNA Evidence. Number 7, Rules on Electronic Evidence. Number 8, Rule 115 of the Rules on Criminal Procedure. Number 9, RA number 4200 or Anti-Wiretapping Act. Number 10, RA number 9372 or the Human Security Act. Number 11, Substantial and Remedial Statute and Number 11, the Comprehensive Dangerous Drugs Act of 2002, provision of the chain of custody rule. Number 12, substantial and remedial statute, and number 13, rulings of decision of the Supreme Court. Question number 7. What are the assume or requisite of admissibility? Evidence must have such relation to the fact in issue as to induce belief in its existence or non-existence. Evidence on collateral matters shall not be allowed except when it tends in any reasonable degree to establish the probability of or improbability of the fact in issue. And the last question number 8, what are the difference between admissibility and weight? Admissibility of evidence is the substantive feature of evidence as would make it worthy of consideration by the court. Weight of evidence is the probative value of evidence as given to it by the court. That's all, ma'am, and thank you.